Good morning, everyone. We'll go ahead and get started. I know folks are still making their way into the webinar, but we have a lot to cover today, so I want to make sure that we get through it. Welcome to our monthly Cal OSHA webinar series. This month, it is on preparing for and managing Cal OSHA inspections and citations. As many of you know, Cal OSHA is one of the most aggressive state plan states. And although my colleague Sam will talk about in a minute that they are severely understaffed, that certainly hasn't meant that they are not enforcing, and they are still being incredibly aggressive, and they are on a push to get more inspectors. And so we anticipate that inspections will only increase, and certainly with the new SB 553 workplace violence statutes, indoor heat, a lot of new things that are coming down the way in terms of enforcement, as well as some new tools that Cal OSHA is looking to put in place. The egregious and enterprise-wide classifications are starting to make their way through the rulemaking process that will certainly affect inspections and citation management. And, one of the other things to also keep in mind, and I'll be talking about at the end of our presentation today, is the new Fed OSHA Worker Walkaround rule, how that will be affecting Cal OSHA. And one of the important things that I think everybody on this call should keep in mind as we work our way through this presentation is that think about your own policies and procedures that you have in place for managing inspections and how they may need to be updated and revised with all of this information we're going to provide you today. This is a really good time to do that as we look to some increased enforcement here in California. My name is Rachel Kahn. I'm a partner here at Kahn Maciel Carey, and I'm a chair of the California practice based in the San Francisco office, where I focus on all things occupational safety and health, particularly Cal OSHA. Also work with employers on the rulemaking process. And I joined Kahn Maciel Carey last year. And before that, I was a partner and led the OSHA practice at Nixon Peabody. And I am joined today by my partner and colleague, Megan Shaked, who is also in the San Francisco office with me. And she focuses on inspections, investigations, everything Cal OSHA, as well as employment litigation, administrative actions, and counseling on employment laws here as well. And our colleague Sam Rose, who is in our Los Angeles office, is also joining us on the webinar today, who has a dual practice license in both occupational safety and health, Cal OSHA, as well as employment support, compliance, and litigation. So have both sides of the house represented on today's webinar. And so our agenda for today. So we're going to be walking through employer goals during the Cal OSHA inspection. So what your goals should be as the employer. And, that probably seems pretty obvious in terms of hopefully not get citations, but we'll break it down to all of the different things that you should keep in mind and be prepared for. We'll also talk about Cal OSHA's rights, employees' rights, and your rights during the inspection process to make sure that you're covered and you understand the rules of the game, for lack of a better word. We'll go through managing each stage of the inspection, and then what to do after Cal OSHA issues citations if that unfortunately happens. We'll do a quick review of Cal OSHA reporting requirements, because of course that's one of the main ways that we see the catalyst of inspections. So you want to make sure that you get those reporting obligations right. And those are always easy citations for Cal OSHA and easy repeat citations. So want to make sure that everybody has the latest on there. And then, as I mentioned before, I'll talk about the worker walkaround rule that expands who can participate in inspections and third-party employee representatives that can be on site. Now, that is a federal rule, but the state plans have 6 months to adopt it. Cal OSHA has indicated that they will be adopting it, although it may not be verbatim the Fed rule. So we'll walk through starting to prepare your workplaces for that as well. And with that, I'm going to hand it over to my colleague, Sam Rose, to kick us off.
Thanks, Rachel. So we'll start off with some background, basic information on Cal OSHA inspections. And the first topic in that section will be, as Rachel mentioned, the goals of a Cal OSHA inspection, or the employer's goals when they are involved in an inspection. There's really 4 overarching goals that you want to accomplish. The first is control the flow of information. Cal OSHA has the ability to request a lot of information, interview employees, interview managers, and so you really want to, as best you can, control that process and make sure that they're only accessing the information that they're entitled to access and that falls within the scope of the inspection. The second is to minimize business disruption. It's very disruptive to have a Cal OSHA inspector on your work site, especially if employees are working and it's the middle of the workday and they're walking around your work site. So you just want to minimize that disruption as best you can. Casting the workplace in the best light, obviously a very important aspect and goal. You want the inspector to look at your work site and see a safe workplace so that they aren't thinking about all the different possible citations they can be issuing at that time. And lastly, identify potential problems early. The earlier you identify a problem, the earlier you can correct it and potentially prevent it from getting worse or out of hand and getting a more serious citation from Cal OSHA. So those are the 4 goals of the inspection that you always want to have in mind when a Cal OSHA inspector comes to your work site and starts their inspection. So the division can begin a inspection when it has a reason to believe that an employment or place of employment is not safe, or employees are potentially at risk of injury. It can do that on its own without any complaint, or in the case of a complaint from an employee, it must go and investigate a complaint from an employee. So there are 2 types of investigations under the labor code. There's discretionary investigations and mandatory investigations. This was sort of covered in the slide before, but just to make it very clear, the division may investigate when it learns or has reason to believe that a workplace is not safe. It's not required to, but if they have evidence that there's some sort of violation on a work site, they're allowed to go and investigate that. A mandatory investigation is when they receive an actual complaint about an unsafe work site. In those scenarios, the division must go and investigate those complaints. And those complaints can come from 2 different places: an employee or an employee's representative from a union, or from a prosecutor or local law enforcement agency who suspects a serious violation. So there are technically timelines for when the division must begin to investigate a complaint. It's within 3 working days after receiving a complaint for a serious violation, and within 14 calendar days after receiving a complaint for a non-serious violation. These are fairly non-specific deadlines because it doesn't preclude the division from issuing a citation if they violate the time in which they start the investigation. So the idea is that they must at least initiate the inspection fairly quickly, but it doesn't prevent them from issuing an enforcement action if they don't comply with the deadlines. So if an employee or an employee representative files a complaint with Cal OSHA, that person's name must be kept confidential by the division unless the person requests otherwise. So if a Cal OSHA inspector comes to the worksite and they tell you that they're there pursuant to a complaint, the employer doesn't necessarily have a right to know who the person that filed the complaint was. And unless that person specifically tells the division that they're okay with that information being shared. So as Rachel mentioned in the intro, we just wanted to put a little note here about staffing before we get into some of the actual inspection details. Cal OSHA continues to struggle with excessive vacancies at both the COSHO and district manager levels. As you can see on the slide, there's 11 district offices that have COSHO vacancy rates at or above 40%. The Cal OSHA inspector to worker ratio in California is 1 to 118,000 workers. Washington and Oregon, who are the two other strong enforcement agencies on the West Coast, have significantly more inspectors per worker in their states. And so it's just an example of how much Cal OSHA is struggling to fill vacancies and operate at a high level of enforcement. They also only have 6 industrial hygienists among their COSHOs. So that really limits their ability to conduct certain types of inspections, especially when it comes to illnesses. In the PSM unit, they are trying to double the size of that unit, despite the fact that they do already have significant vacancies within the current level of staffing. And then on the Bureau investigations front, which is the part of Cal OSHA that conducts criminal investigations or criminal referrals for really, really strong violations, they only have 1 investigator for the entire state. So if you have a matter that is put on a hold for a BOI inspection, we're seeing these delays for months or even years because the one investigator doesn't have the bandwidth to investigate all of the current matters that are on BOI hold. And they have up to 3 years to conduct that investigation while the Cal OSHA matter is stayed. So we're seeing very, very long delays on those types of matters. That said, despite all of these vacancies, we're still seeing a flurry of inspections and citations, and Cal OSHA really continues to enforce the standards at a very strong rate. So we can only expect that as Cal OSHA continues to fill these vacancies or attempts to fill these vacancies, that the enforcement will become even stronger going forward. So we just want to give a note on the scope of the investigation or the COSHO's inspection. The division really does have the authority to obtain a wide variety of information and data and documents from an employer during a inspection. They are able to obtain statistics or physical materials that are within your possession as the employer, so long as that information or documents are directly related to the purpose of the investigation. They're also able to conduct tests on your worksite, take photographs of the worksite, and then discuss safety or health violations or problems with any employee or their representatives. And we'll discuss a little bit further how your rights and the employee's rights in those interviews. So a quick note on your employees' rights during an inspection. Employees have a right to file a complaint and to not be discriminated or retaliated against for doing so. And then in the context of the actual participation within the inspection, they're able to participate in the opening conference during the COSHO's walkaround and during private interviews with the COSHO. In terms of the employer's rights during an inspection, an employer has a right to demand an inspection warrant, and we'll go into this a little bit further shortly. An employer is absolutely permitted to protect their trade secrets or confidential business information. They are entitled to accompany the inspector at all times during the inspection. They can appeal or challenge citations. And very importantly, the employer is permitted to participate in all management interviews. So the COSHO does not have a right to interview any of your management witnesses without an employer representative present. And that could be another manager or an attorney. So just some ideas to have before an inspection occurs. You definitely want to review any applicable special emphasis programs or compliance directives that might be on point for your industry or for your type of business. You want to review Cal OSHA's policy and procedures manual for inspection procedures to just have a double check that the COSHO is conducting the inspection in a proper manner. We've developed an inspection toolkit. I think many of you might already have it. If not, you can feel free to reach out to us for a copy of it, but you definitely want to review that inspection toolkit. There's a lot of really helpful information in there and really helps narrow the scope of the investigation. You also want to review any internal Cal OSHA inspection policies, designate specific walk-around routes where you're going to bring the inspector so that they're not just walking aimlessly around your work site, potentially finding additional violations that they're not there to find. And you'll want to develop your organization's philosophy on warrant and consent. You are entitled to consent to an inspection, but you're also entitled to have a inspector or the division go get a warrant to enter your work site. And there's strategic reasons why you might do either one, and you just want to kind of determine what your philosophy will be and whether that's determined by the type of inspection that you're expecting or whether that's from a complaint or a sua sponte inspection. It might differ, but you just want to make sure you have that idea set for your employer. So there's various stages of a Cal OSHA inspection. Obviously, they start with an opening conference, which is when the inspector meets with various representatives from the employer to open up the inspection. There is the document production phase, which is where Cal OSHA issues a form asking for various documents be produced within a certain period of time and that the employer must comply with. There's also the walk-around inspection, which is where the inspector actually walks around your worksite looking for violations. And then the employer interview process, where they interview employees about various health and safety issues at the worksite. And that can vary on a wide range of topics, depending upon what they're at the worksite for. The inspection ends with the closing conference, which is where they discuss what they found during the inspection. And then if there are citations that they will issue, those citations get issued, and the employer determines whether they want to contest those citations. So as I briefly explained, the opening conference is when the COSHO arrives, shows that they're a COSHO, and asks to inspect the worksite. At that point is when the employer can agree to have the inspector come on site and conduct their inspection, or tell them that, we're not consenting to this inspection and you need to go get a warrant from the court. You have a right to do that, and they can't enter your worksite without consent. So that's where that warrant issue comes up most frequently. That's also where the COSHO can request various documents on the spot. So there's the document production, which is when they provide a form and ask for documents to be produced, but they can also ask for example, your IIPP or your heat illness prevention program on the spot and ask that you give it to them at that moment. It's also where the COSHO will discuss the scope of the inspection. So if it's from a complaint, it might be limited to the machine or the hazard that relates to the complaint, or it could be a wall-to-wall inspection where they're just inspecting the worksite generally and going all over to look for violations. And they'll, at the opening conference, they'll tell you which type of inspection this is. So the warrant or consent issue is one that doesn't come up often, but especially as Rachel will talk about later in the presentation, the worker walkaround rule might change a lot of employers' perspective on this issue, depending upon who is trying to access the worksite. So the Fourth Amendment is the prohibition against unreasonable searches and seizures. That applies to Cal OSHA and applies to your worksite. So they are not allowed to come onto your worksite without a warrant or without your consent. There's a few benefits and risks to warrants, and then a few benefits and risks to consent. The benefits of a warrant are that it restrains Cal OSHA, and if you tell Cal OSHA to go get a warrant, that buys you some time, knowing that the COSHA is going to go get that warrant, gives you some time to get your worksite in order and potentially identify any hazards between the time that they arrive and the time that they come back. The risk of the warrant, obviously, is that the inspector is now having to go get a warrant. They could potentially retaliate against the employer or issue more severe citations because you've made them go through this work to go access the worksite. And also in a way that takes the control of the inspection out of your hands because the COSHA is going to be on a mission to go through your worksite now that they have a warrant. The benefits of consent is that you appear cooperative, it's easier to manage, and it minimizes the business disruption because you have the COSHA and you're following them around the whole time. The risk of consent is that the scope of the inspection is expanded. There's not a warrant restricting where they can go and what the inspection is related to. So on the issue of the warrants, there were two appeals board cases that came out within the last year that were related to Calvary Chapel of San Jose. In these cases, two inspectors were denied consent to inspect the employer's worksite. They went to the court to get a warrant, and the warrant was supported by an affirmation from the inspectors saying that they had received a complaint about this was related to COVID and people not wearing masks. And that when they went to the worksite originally, someone came out and met them in the parking lot not wearing a mask outside. And they put that information in the affidavit to support the request for a warrant. The court issued the warrant and the inspectors conducted their inspection and later issued, I believe it was five citations to the employer, all related to COVID. The case went, basically the employer had filed a motion to suppress all the evidence from the inspection because there was no good cause for the warrant. And they argued that the warrant was deficient and that the inspector should have known that it was deficient and did not make out good cause for issuing the warrant. And that there was just not enough information to establish good cause. They filed a motion to suppress all the evidence and the ALJ agreed. The division appealed and the appeals board said, we agree that there was not good cause here. The affidavit was insufficient to establish good cause and the warrant was unjustified. Rather than suppressing the evidence, they sent it back to the ALJ to determine whether there was a good faith exception to excluding the evidence from the case. The ALJ found that there was no good faith exception that applied, and it went back up to the appeals board to rule on that issue. The appeals board held that while the good faith exception does apply to appeals, that the ALJ was correct, that in this case there was no good cause exception applied. It specifically held that there's 4 scenarios where the good faith exception does not apply. That's when the issuing magistrate is misled by information in the affidavit. The magistrate just abandoned their judicial role in granting the warrant. The affidavit was lacking in probable cause, and so it was entirely unreasonable for the inspector to believe that there was good cause or that the warrant was facially deficient. And in this case, they found that because the affidavit only mentioned that there was a complaint and that they observed someone not wearing a mask outside, that was so lacking in indicia of probable cause that there's no way the COSHO could have believed that probable cause existed. There was no information about who made the complaint, why the complaint was viable or to be believed, that it wasn't being made for malicious purposes. It was just a very basic drafted affidavit. And so the appeals board held that that was not going to be permitted and suppressed all the evidence in the case. So with that, I think we'll turn it over to Megan to discuss the next steps in the process.
And maybe we'll just take, before Megan jumps in, we can take a couple minutes I know there's some questions in the chat, and we'll take some of those now. And if we have some time at the end, and then of course you guys can always email or call any of us as a follow-up. One great question, what if Cal OSHA won't tell you what the complaint is? So this is a little different than the federal rule, where they do so. In California, they cannot tell you the identity of the complainant. And so many times they will also not tell you what the complaint is if they feel that in some way will disclose the identity of the complainant. So, which of course can be very frustrating because you're having Cal OSHA come on site, and it really hinders your ability to put parameters around the potential inspection and have a strategy in place. So one thing I like to do sometimes in that scenario is put it back on Cal OSHA and say, if there's some allegation that there is an unsafe condition in my workplace, if I don't have knowledge of what that is, I can't take steps to remedy it. And so, try to put it on them that if there's some allegation, something's not safe, the employer should have some knowledge of what that is. Sometimes that works, sometimes that doesn't work. I also, in the opening conference, in some of the documentation that they ask for or places that they request to see can give you an idea of what the complaint is. And I saw one other question about former employees and whether or not that's treated the same. And former employees are certainly a source of complaints to Cal OSHA. We see it frequently when maybe there is a termination or dismissal of an employee, and then you might get a complaint not too long after that. And so those are treated the same as if it was an employee making the complaint. So I think, Megan, I don't know if you see any others in there or if you want to have anything to add, or I'll turn it over to you.
Sure. Yeah, so we're gonna drill down a little bit more in detail about, kind of tips and how to handle these on-site inspections, and recognizing that sometimes Cal OSHA will choose to send, a notice of hazard letter, and that there's an opportunity to handle response to that in writing, which is kind of another category of inspection that we would, be happy to assist with if that's the need. But for today, we'll kind of give a high level overview of how to best handle when they actually show up on site. And one of the things that is very common is that it creates a huge sense of urgency for the employer who deals with Cal OSHA showing up. So one of the things that is good to have in place is, processes, and also just the the habit, the practice of taking a minute, slowing down, thinking through what's happening, and making sure that the employer is in control of the inspection. And to the extent possible, isn't simply reacting to Cal OSHA, but does have a handle of how it wants to handle these inspections, what the various decision points along the way, like what the employer wants to do. So one of the things is, taking a second, setting up the inspector in an office, giving yourself an opportunity to get the proper safety person or, the highest level person in charge at the site, getting OSHA counsel on the phone, whatever it is, to make sure that you have the resources at your fingertips, you have the people who you need to be aware of what's happening, so that you can best be prepared to respond to the COSHA's requests while protecting your rights as the employer. And so, insist on having that opening conference, insist on having a conversation with the COSHA to understand what is the nature of this inspection. Is this an inspection that's been targeted by a program, for example, the high hazard unit, right? And is it within the parameters? Is it properly within that programmed inspection? Or if it's a complaint, as Rachel was saying, is there a scope of the concern? Is there particular areas that, you can get an idea of whether this is going to be limited to certain areas or certain issues, or whether this is going to be a broad wall-to-wall inspection that could cover any area of the work site. Figure out, like I said, who's going to be involved. Figure out who's going to, walk around with the COSHA, all of those details, right? Get a sense of the documents that might be requested. If a COSHA, there's certain requirements for producing documents right away or within a very short period of time, 4 hours for example, OSHA inspection records, inspection logs. So you want to know if the inspector's asking for those at the very beginning, you want to gather those and give those to the inspector right away. Other documents, if it's going to be a really extensive request, you can maybe start to pull documents in the back, behind the scenes, because it's very frequent that the document request, even if it's not requested during the inspection, it's a pretty short turnaround. We've seen them, 3 days later, all of the documents are due. You want to think through what your interview protocol is going to be. Are you going to prepare witnesses who the COSHA asks to interview? Are you going to, take advantage of your right as the employer to make sure that no management, member of management is interviewed without a representative in that room, which would be our recommendation? Are you going to insist that counsel is involved in those interviews, excuse me? And what steps do you have to take to make sure that those interviews, that you have control over the scheduling of those interviews? If you think the inspection is going to go on for multiple days, it's good to arrange for a closeout meeting. So again, you maintain control. You have a little bit, while the initial inspection, they do not announce it. They show up unannounced, and you don't have, generally speaking, you don't have a heads up that they're coming. Once the inspection has started, you have a little bit more control. So if there's a certain person that needs to be interviewed, or a certain, detailed thing that needs to be arranged for, you can have those conversations with the COSHA, and again with assistance of the proper people, whether it's your safety folks or OSHA counsel. And that's another way, when you kind of have control, you can make sure that any other concerns, the safety of employees who are working out on the floor, for example, or proprietary or trade secret information that it's being protected, if photographs are being taken, you have time to think through the issues that this inspection might be triggering. Again, just some additional notes on the document production. Sometimes we'll get inspectors who just will say, hey, can you give me X, Y, or Z? Really, it's important that the requests come in writing for a few reasons. You don't want there to be something that falls through the cracks, but you also, these inspections, they have a 6-month period of time. And so sometimes an inspection might open, let's say the beginning of August, and a few months down the line, you're still having some follow-up conversations. And then perhaps even further down the line, if there are citations issued and an appeal, and you get the inspection file back from the division, and you realize, wait a minute, some documents that we provided aren't in here. And you want to have a conversation with the division about, did you take into consideration this document in issuing the citations? A good way to keep track of that is to have a clear record of the documents that were requested and then the documents that were provided. Along the same lines that Sam was talking about the scope of the inspection and the warrant, if there are disagreements about the scope of the documents to be provided, there might be certain documents that are provided willingly and certain documents that are insisted on by the division through a subpoena process. So kind of thinking through where on the scale you are in the ability to provide documents, or whether you really need some limits and you need the court involved to help create some boundaries on what is provided during the inspection. Now, a lot of the inspections they can be very different depending on the COSHA you're dealing with, the issues at play. But generally speaking, you don't want to be creating new documents that are being requested. Their request is generally for the things that exist at the time of the inspection. And the other thing to keep in mind is that, you may limit the scope of the inspection, but there is this concept of what's in plain view, right? So if a COSHO can see a violation, even if it's outside the bounds of the scope of the inspection, it's something that they see. It's something that's fair game for them to issue a citation on or further investigate. The same thing would go for documents. So if something is in plain view, it's something that they may review. Another thing to keep in mind is, you do all this hard work to establish the scope of the inspection. You don't want to unnecessarily expand the scope by providing information that the inspector is not asking for. They're there to get information, and it's their job to get that information. And our recommendation is to try to limit. Obviously, you want to be cooperative and you want to help the inspector understand what they're looking at, but really try to limit the information that you're volunteering outside of a document request or an interview. And then, of course, you can review the documents for responsiveness. Sometimes you have to clarify what the inspector is requesting, and sometimes you have to put limits based on privilege or confidential business information or other things like that. I mentioned some of the documents that are commonly requested, like those OSHA logs that might be requested at the beginning and need to be provided right away. Some of the documents in California that we see requested in many inspections. The IAPP, for one, that's something that they have to evaluate. They have to evaluate the effectiveness of your injury and illness prevention plan. So that starts with taking a look at the document. Things like your heat illness prevention plan, your workplace violence prevention plan, and yes, even your COVID-19 prevention plan. Those are still being requested by the COSHOs. And then sometimes, given the nature of the inspection, it will give you an idea of the sorts of documents that they might be requesting. If there's an incident or an injury, there might be requests for, investigation documents, inspections. There might be things that are specific to the equipment at issue, and different things that are custom for certain industries. Healthcare or construction, you might be accustomed to the same sorts of documents that might be requested. This is, again, just a reminder to keep track of the documents that you're producing. Sometimes there's more than one request, so it's an easy way to keep track of it. Oh, excuse me. Okay. Excuse me. I'll go through a little bit the walk-around inspection, and some of the information from our toolkit is being provided on the right-hand side that just gives a little bit more detail. So in respect of everybody's time, we'll try to just give some of the basics. And again, if anybody has any questions or wants to talk in more detail, we're happy to. For the walk around, this is where you're actually physically walking around with the co-show. You want to make sure that some representative of the employer, whether it's an employee of the employer itself or OSHA counsel or representative, is walking with the co-show, that they are taking side-by-side images, that they're keeping track of which areas of the work site are being visited, who the co-show is speaking to. Again, acting professionally, but there to make sure that the inspector is conducting the inspection properly and that the employer's rights are being protected. There's a range in how experienced the inspectors are. And so it's good to be the most prepared. It's always good to be the most prepared person in the room to be able to push back gently and respectfully, but if needed. And also, you're there to make sure that employees are working safely, that the co-show is operating safely, right? Or that you don't let them go into an area that's unsafe. If you have requirements for guests to wear protective equipment, for example, that you're making that you're holding the inspectors to those standards as well. Just again, some additional tips here, making sure that you're keeping track of the scope of the inspection, so that if you need down the line to understand, wait, that's, what he expressed a concern or she expressed a concern about X area of the work site, but we didn't visit that area. So you can understand, where did that come from and what are the concerns? To Rachel's point about, what if they don't tell you about the complaint? If the goal is to make sure that the work site is as safe as possible, and there's a concern that creeps up into the inspection through something other than the walk around and an interview with a witness or something like that, you want to make sure that you're tracking that. Okay, so when it comes to interviews, so there's kind of two categories. You have the management interviews where the employer has a right to be present in those interviews. And then you have the non-management employees interviews where that right belongs to the employee. So the employer cannot insist in being in that interview, but the employee has a right to a representative in that interview if they choose. So you want to make sure that the interviews happen in a safe manner, of course. If a co-show tries to interview somebody, on the spot, on the floor, we try to really limit those with the goal of making sure everybody is working safely and that the flow of the operations is not interrupted. So, making sure those interviews happen in a safe place where the witness can hear, conference room, or an area where they're not going to be distracted by the work environment. The issue of, again, a warrant, a voluntary interview versus one that has to be subpoenaed. This is another area where that issue crops up. Here are, this is really important to review all the details about the employee's interview, the employee's rights. The division and employers should, always be concerned that the employees are not being coerced or intimidated into giving information that might not be accurate. And certainly that there's no discrimination against them for their participation in the inspection. For the supervisory employees interviews, the really, really important thing to remember is that supervisors' information that they provide during these interviews is an admission by the employer. So this is why it is so important that those folks be prepared adequately for these interviews and that the employer is represented in these interviews as well. And we can, get into, there's additional details about preparing management level folks for interviews as well. This is a great resource for preparing employees for interviews across the board. These are great tips that apply no matter what, whether they're a supervisor or not. And it's a good resource to go back to anytime you are faced with potential interviews, to remind yourself and to be able to remind folks of those good tips, because people get nervous and it can be intimidating to be interviewed by a government official like OSHA. So the closing conference, we did just want to mention, and again, these slides will be available for review. But one misconception we get sometimes is that they have to conduct a closing conference. They don't have to. Their policy and procedure manual says that they should, and they usually do, but we have had occasion where they do it via email, or they run up against their 6-month deadline and they don't do it. But this is the opportunity for, it's a good reminder to know that citations are on their way, so you can make sure you receive them and meet your appeal deadline if you choose to appeal the citations. It's also an opportunity to have the inspector talk through, what are the citations, what is the basis for them, and some additional details about the appeals process. The closing conference, if you do have an opportunity to interface with the COSHO, it's, they tend to kind of follow a script of information that they provide. There is some opportunity, there's a range in how inspectors handle these closing conferences, but there sometimes is an opportunity for some dialogue with them. You don't want to admit that there have been any violations, but if there are questions you have about when you might expect to receive the citation, or what the division might be looking for if there's an abatement concern, there is some opportunity for conversations sometimes with some inspectors. 2 more points I want to cover before passing it off to Rachel, is that there is a form known as the 1BY, which is the Notice of Intent to Issue a Serious Citation. This is required. This is in the labor code. The division has to issue it at least 15 days before they issue an actual citation that is classified as a serious. They call for a response. The notice that you receive in the mail calls for a response, but it's really important for employers to remember that they do not have to respond to this. There is no adverse inference that can be drawn from an employer's election not to respond, and they're not waiving any defense that they might make in an appeal down the line by not responding. This is, can be a case-by-case decision about whether an employer chooses to respond to this, but this is an area to pay very, very close attention to, because anything that you provide to the division would be part of a pre-citation consideration that the division would have. It wouldn't be protected by any settlement privilege, and it could be taken into consideration by the division in issuing citations. Sam mentioned that the Bureau of Investigation is within the division, and they exist to particularly review and investigate fatality and really serious injury cases for whether there are potentially criminal violations that would justify a referral to criminal prosecution to district attorneys or the state attorney general. BOI has severe staffing shortages, but it's also it's something that will happen in fatality cases or catastrophic injury cases. And with that, I will pass it to Rachel to wrap up some additional topics that are really important in these investigations.
Thanks, Megan. A couple additional questions in the chat. I'll just hit really quickly because I know we only have 10 minutes left and we have a lot of time, or a lot of other things to cover. The employee does not have to participate in an interview if they decide that they do not want to participate. However, if they decline, OSHA could always subpoena them. So I don't see that too often. Most of the time, if I see if an employee declines, most of the time I see it kind of just let go, but it is possible that they subpoena them. One of the things I'll say also about the 1BYs is that lately I have seen Cal OSHA try to give verbal notice to employers at the closing conference or after the 15-day period. And basically, the 1BY it creates a presumption that it's a serious citation. It doesn't necessarily preclude them from issuing a serious citation or one of the other categories. So keep that in mind as well. It's a little bit of a funny process, and a little bit in the more we kind of see them taking a different approach to that notice, I'm sure we'll see some additional litigation about how that notice is going to be used in the appeals process. And with that, I will do a very quick reminder of Cal OSHA reporting requirements. Again, this is just, one of the easy ways that Cal OSHA can get you cited in a important to remember and to remind your management folks. So we can head on to the next slide. So employers must immediately report any serious injury or illness or death that occurs of an employee occurring in the workplace or in connection with the workplace, and immediately and as soon as practicable, but no longer than 8 hours. One of the things that I want to remind employers of, and this is, I see this happen all the time, is that the clock starts when your managers, if you have a manager that's informed of the serious injury or illness, not when EH&S, not when the person that as the person that informs Cal OSHA finds out. If a manager finds out, that's when your clock starts running. And I see, I would say probably half the time, that's where I see late reports come in, is that we find out later that a manager was advised of the serious injury or illness before it made its way up to EH&S or to the other folks in the organization. And here's additional information here about how you can report and where to report. And again, just a reminder here on the serious injury and illnesses defined in several years ago. This changed slightly, I think, 2017. So if you have some old policies or procedures floating around your facilities, make sure that it includes the updated definitions that went into effect, I think, pre-COVID. But again, one of the big takeaways that I want to make sure people take away from this webinar is that this is a really good opportunity to make sure that all of your policies and procedures around inspections are updated. And if you do not have one, this is a great time to get that in place as well. And this is a list for all of the information to provide to Cal OSHA when you're making a report. So make sure you have this information to the extent that you have it on hand before making your report. And all of these slides will be available and sent to everybody at after this presentation in the next couple of days. So don't feel like you have to jot all this information down. We'll provide it to you as well. And this is just a quick, Cal OSHA hasn't posted the top violations for 2023, but the reason that we include this information is because it really doesn't change. I mean, mostly take out probably the COVID and the COVID number 4. IIPP violations are always going to be the top. Heat illness, reporting, those are always going to be the top of the list. And why do we include those? Because these are the things that we know Cal OSHA is going to ask for. We know that they're going to be looking at. They're the things that are ripe for repeat citations. So this is a really good time now to just take stock of those things, make sure you have them in order, review them, because we know they're going to be on top of Cal OSHA's list. So worker walkaround rule. Now, as I mentioned before, this is a federal rule that went into effect in May of this year. and it kind of bounced around a little bit. There was a letter for interpretation, allowing additional third-party participation that got challenged. The letter got rescinded. And then fast forward to last year, when they revised the regulation, as we can see on the next slide. And so OSHA initiated the worker walkaround rulemaking process. It got published earlier this year, and it went into effect on May 31st of 2024. And now all state plans will have to adopt it within the next 6 months, or one that's at least as effective. So what does the final worker walkaround rule mean, and how does it affect the inspection process? So what it does is it eliminates extreme bias against third-party involvement in OSHA inspections. So it increases the types of third parties now that can be permitted in OSHA inspections. So as you can see from the language here, which is the final language, representatives authorized by employees may be an employee of the employer or a third party. And within the judgment of the COSHO, if there's good cause, they can accompany the COSHO on the inspection. So this expands significantly the individuals that can potentially come on site. So employees can now have an additional representative that can be a third party that can be on your site. So why is this so important? Who could these potential third parties be? So a third party could potentially be a union representative at a non-union or a union workplace, potentially be a disgruntled former employee. It could be media or a journalist, plaintiffs' attorneys or their experts, worker advocacy groups or activist organizations, other attorneys or consultants, technical experts, competitors, customers. So as you can see, there's really not a, there's some limits to who can be involved. It's really going to be at the discretion of the COSHO to see that they provide additional information that would essentially be useful in the process, but it can really range. And so that's why this is really an important time to put into your policies and procedures. If you have an inspection and a third party shows up, what are you going to do about it? So what are the risks of this potential third party? Now, again, we don't have this in California yet, but California is required to adopt it. So now is the time to kind of get your ducks in a row and start to think about this. So access to employees for union organizing or influencing and bargaining, increase in complaint and filings, potential influencing of witnesses, early access to sites, access to trade secrets, and information that just could potentially be used to criticize or shame the employer publicly. So what are some top strategies? Make sure that you're designating and you're training an OSHA inspection team to manage inspections if you don't have that already. Make sure you, again, have a policy in place, or if you already have a policy, making sure that it is updated to include this type of information. As Sam talked about earlier, have a warrant strategy. If a third party shows up at the inspection, are there some that you're always going to deny entry to? Are there some? How are you going to escalate it? How are you going to work with OSHA and say, you, OSHA inspector, are allowed on site, but third party, we will not allow on site. And this may require taking a more aggressive stance in requiring a warrant. Are there types of questions that you're going to ask the third party to ensure that they have the relevant information that the COSHO needs to make the determination that they should be a part of the inspection. You can also develop confidentiality and non-disclosure. And now this has to be for all invitees. It just does not have to be for employers or just for third parties. It has to be for everyone. Make sure you're enforcing PPE requirements across the board. And consider potential workplace violence restraining orders against disgruntled employees before they may come back on site through this process. Ensure that you're designating sensitive areas in your workplace that might be subject to trade secrets. Establish a safety committee or specialized work groups that can be utilized instead of this third party. If you have a multilingual work site, make sure that you identify potential interpreters, so a third party doesn't have to be brought on site. And of course, just make sure that you're promoting channels for employees, anonymous or otherwise, to raise concerns to management. So those are all strategies you can use in this new world of potential third parties involved in inspections. Our Fed OSHA team has a whole webinar on the worker walkaround rule that you can find on our website if you're interested in learning more about it. And any of us are happy to get that, go through that in more detail. I know we're almost out of time, so we didn't get into it in a ton of detail, but again, it's something that you should be preparing your work sites for now before it becomes effective in California, so you can ensure that your folks understand and are properly trained in that process. And just as a reminder for everybody on the call, we have our blogs that you can subscribe to, that we provide all updates on everything that's going on to Cal OSHA, but you need to subscribe to it to get those updates, and we have them for the Fed OSHA side as well as employment. We have a variety of different services and master classes, including our OSHA inspection master class. That is a several-hour in-depth master class where we go through all the more in-depth strategies on how to manage a inspection. And we have coming up in October our Cal OSHA in California Summit. So October 8th in Berkeley and October 10th in Pasadena. And we have several panels on all of the things that are going on with Cal OSHA, the interaction as well between OSHA and labor law, and updates on employment. So that will be a full day summit in both locations. And it was a great summit last year, and we're looking forward to it again this year. And then lastly, we are rolling out our rulemaking coalition that will provide comments and other advocacy through the Cal OSHA rulemaking process. For some of you that may be aware, the new workplace violence prevention regulation draft is out, as well as the draft for revisions that will include egregious and enterprise-wide classifications and a lot of different other rulemaking that's coming up. So providing an avenue for employers and companies to participate in an anonymous way through our coalition. And if some of you may be familiar with how they do it here on the federal level, and we'll be doing that here in California as well. So thank you everyone for joining us. If you have, I know there was a lot more questions that we weren't able to get to, please feel free to reach out to us directly, and we're happy to answer those. In the next several days, or maybe early next week, you will be getting a copy of the webinar as well as the slides. And just a reminder, if you are not able to ever attend one of our webinars, go ahead and sign up and register, because if you're registered, you will get a copy of the recording and the slides post webinar. So thank you, everyone, and have a great rest of your day.